Hello, class, and welcome to Chapter 8, Pretrial Procedures and the Criminal Trial. So we're going to be talking about the pretrial criminal process to begin with here. And oftentimes we talk about a wedding cake model. So when we're talking about the court system, and only the top and the smallest layer of trials are really coming to closing come close to meeting constitutional standards of procedural justice. So on the bottom layer, which is the largest layer of the wedding cake, the vast majority of defendants are dealt with informally. So we start off with an initial appearance, and this is defined as the first appearance before a judge or a magistrate. And this is a brief proceeding. And at this proceeding, the defendant is notified about the charges that were brought against him. He or she is also notified about their constitutional rights. They're protected by the Fifth Amendment, the right to remain silent, and of course the Sixth Amendment, the right to be represented by counsel. And at this point, if the defendant can't afford to hire an attorney, then a public defender will be appointed for the accused. So the U.S. Constitution doesn't specify how long until this needs to happen after arrest, but really most states are looking at having this happen within about 48 hours. Really depends on the day of the week. If it's a weekend, it might be a little bit longer. I'm so sorry, I'm yawning in your face. I don't mean to. Let's move on. Okay, so pretrial detention. So misdemeanor cases usually are not going to be held on pretrial detentions. That's going to be something that's saved more so for felonies. And a defendant can't make a plea at a pretrial hearing in a felony case. That's a little bit different. So bail needs to be determined at that point. And what bail is the dollar amount or some sort of conditions that the court has to set to ensure that that individual that's being accused of the crime will come back, right? Will come back for trial. So we talk about preventative, first I want to talk about, let's talk about preventative detention. So that's when we're keeping somebody, retention of an accused person. So we want to make sure that there's no future crimes. Are they a risk to society, to the community? They're going to look at all of these factors when they're making a decision about preventative detention. So bail is provided under the Eighth Amendment, and the amendment doesn't guarantee the right to bail, but what it does is it states that excessive bail shall not be required. And this basically means that it has to be reasonable, right? They need to look at all the factors that go into play as far as the safety of this person and the community that they would be released into. So in theory, bail is not really intended to be a punitive measure. It's just designed to provide this incentive for that defendant to return to court and continue to participate in the legal proceedings. There is really no uniform system for setting bail. Every jurisdiction is going to have some different guidelines they're going to be looking at, but there will be guidelines. So it's not just, the judge can't just make a random decision. For misdemeanors, the police are usually following some sort of pre-approved bail schedule. And then, of course, with felony cases, the responsibility to set bail lies with the judge. So let's talk about how the beginning of these hearings start. Once a person is arrested and they have their initial appearance in court. So we have what's called a preliminary hearing. And this is where we've got to figure out if probable cause exists. And during this hearing, the defendant appears before the judge or the magistrate, and they're going to decide whether the evidence that's been presented by the prosecution is sufficient enough for the case to proceed to trial. Now, you may ask, why would we even have to have a preliminary hearing? Why would a prosecution even bring a case forward that they did not feel had enough evidence. Well, there's lots of reasons for this. But normally, every person arrested has the right to this hearing. And they have a right to it within a reasonable amount of rest, usual amount of time on that initial arrest. So the preliminary hearing is conducted kind of in a process of a mini trial. I have been involved in many preliminary hearings. But during the hearing, the defendant has this right to be represented by counsel. And counsel can cross-examine witnesses. They can challenge evidence that's offered by the prosecutor. And in most cases, defense attorneys can take advantage of this hearing to start discovery. And so they can get a lot of information by asking just a few questions. I have always had defense attorneys in preliminary hearings use it as an opportunity to try to get as much information as they can from me as the officer, the arresting officer. And usually that doesn't work because it isn't allowed to go that far. So oftentimes what will happen is a defense attorney will actually waive the hearing. So I can remember with getting hearings waived, showing up at the preliminary hearing, and the defense attorney would come and talk to me. They'd ask me a few questions, and I'd basically say, man, this is a good case. I got X, Y, and Z. And rather than waste the court's time, their defendant's time, my time, they would just waive the hearing up. They know what's needed for probable cause to be met, and they might just determine we don't need to talk about this. Now, if it does, if a waiving does not happen, then of course it will proceed forward. And then from that point on, after that prelim hearing, we go to grand jury. And so grand jury is a group of citizens, and they are selected and serve on grand jury for usually, maybe like 3 months or so. And this is, again, not a trial to determine guilt or innocence. This is to issue an indictment. And if the majority of the jurors find sufficient evidence, they're going to issue an indictment. And so like any information in the preliminary hearing, this indictment becomes the formal charge against the defendant. So let me tell you a little bit about grand juries. Grand juries, like I said, they're impaneled, and so they serve for a period of time. And really, for the most part, grand jury proceedings are dominated by prosecution. They can present a wide variety of evidence against the defendant, photographs, documents, and usually, I think I read, I'm not sure where I saw that just like 97% of indictments that come from grand juries move forward. So generally speaking, you have to remember that grand juries do differ from regular trials. The jurors can ask the prosecution and the judge questions. The defense cannot cross-examine prosecution witnesses. They can present their own witnesses. And the proceedings are very private. They are closed. And if you are a member of the grand jury, you are sworn to no media disclosure. So there are some things that are happening with that. The exclusionary rule does not apply in grand jury investigations, so prosecutors can present evidence that would be disallowed at any subsequent trial. So, I was off on my percentage. It says here, overall defendants are indicted at a rate of more than 99%, leading to common characteristics of the grand jury, a little more than just a rubber stamp approval. Now, prosecutorial discretion involves the power not to prosecute cases. So case attrition is defined as this process by which prosecutors, by deciding whether to prosecute each person arrested, affects an overall reduction in the number of persons prosecuted. And the reason why they go through a process of screening factors And a lot of it comes down to scarce resources. About half of adult felony cases brought to prosecutors by police are dismissed through a null prosequi, and that is unwilling to pursue. And another option is preferred prosecution, in which a prosecutor agrees to delay further actions as long as the defendant's meeting certain conditions. And so there are many things that happen as they're going through and screening their cases to see if they will be a good case to move forward for a possible conviction. So, arraignment. So when we're talking about arraignment is defined as a court proceeding in which the suspect is formally charged with the criminal offense that's stated in the indictment. And at the arraignment, the defendant is informed of the charges, and he must respond by pleading not guilty or guilty. But in some, but not all states, the defendant may also enter a plea of nolle contendere. And what this means is it's really not an admission of guilt, but it's also not a denial of guilt. And the consequences for someone who pleads guilty and for someone who pleads nolle contendere are same in a criminal trial. But most frequently, the defendant pleads guilty to the initial charge or to a lesser charge, and that's what's agreed upon through plea bargaining. And if the defendant pleads guilty, then no trial is necessary, and the defendant is sentenced based on the crime that he or she has admitted to committing. So plea bargaining. Plea bargaining most often takes place after arraignment and before the beginning of the trial. It, in its simplest forms, is a process, and it's a process by where the accused is represented by defense counsel and the prosecutor. They work out this deal. And there can be a lot of motivations for plea bargains. And we know that plea bargains account for about 97% of criminal convictions in state courts. And in most cases, the prosecutor has this single goal after charging a defendant, and that is conviction. So the prosecutor's role as an administrator also comes into play. They want to save money. They know that there might be more hard and fast cases that they're more likely to get a conviction on at trial. So there are all different things that come up that drive a prosecutor for a plea bargain on a case. As far as the defense attorneys and what they're looking for, a political scientist, Milton Human, said that a defense attorney's most important lesson is that, quote, most of his or her clients are guilty. And so when that is truly the stark reality, favorable plea bargains are often the best defense. The plea bargain allows the defendant a measure of control over his or her fate. And defendants who plea bargain receive significantly lighter sentences on average than those who are found guilty at trial. About half of the states now allow for victims to be present and participate in this plea bargain option. And on the federal level, the Crime Victims' Rights Act grants victims the right to be reasonably heard during the process. So in general, crime victims have mixed emotion regarding plea bargains. But generally, a not guilty plea in the face of strong evidence is part of a strategy to do one of the following: gain a more favorable plea bargain, challenge a crucial part of the evidence on constitutional grounds, submit one of the affirmative defenses. And of course, it is either side. If either side is confident in the strength of its argument and evidence, it will be more than willing to go to trial. Both prosecutors and defense attorneys may favor a trial to gain publicity over a case. And others may say this just isn't worth it. It's too weak of a case. So some defendants might, though, still insist on going to trial regardless of an attorney's advice, and that may backfire on them for sure. So what are the basic protections that are enjoyed by criminal defendants in the United States? So these are the things that a defendant has a right to. So we know the Sixth Amendment requires a speedy trial for those accused of a criminal act. And the reason for this is really obvious. So the defendant may lose his or her right to move freely, and they may be incarcerated prior to trial. And if the defendant is innocent, the sooner the trial is held, the sooner his or her evidence can be established in the eyes of the court and the public. So citizens are protected against unreasonable delays before acquisition by statutes of limitations. And these time limits require prosecutors to charge a defendant with a crime within a certain amount of time after the actual illegal act took place. So what does the jury do? The Sixth Amendment states that anyone accused of a crime shall be judged by an impartial jury. And in Duncan v. Louisiana in 1968, the Supreme Court solidified this right by ruling that in all felony cases, the defendant is entitled to a jury trial. If the defendant waives his or her right to trial by jury, a bench trial takes place. And this is where a judge decides the questions of legality and fact, and no jury is involved. In federal courts, defendants are entitled to have the case heard by a 12-member jury unless both parties agree in writing to a smaller jury. In most jurisdictions, jury verdicts in criminal cases must be unanimous for acquittal or conviction. Now, the Fifth Amendment states that no person shall be compelled in any criminal case to be a witness against himself. It is also important to note that not only the defendant has the right to take the Fifth, but also that the decision to do so should not prejudice the jury in the prosecution's favor. We also know that defendants have a presumption of innocence and a strict standard of proof. So the presumption in criminal law is that a defendant is innocent until proved guilty. And the burden of proving this is going to fall on the state, the prosecution. And sometimes, especially when a case involves a high-profile client or a high-profile violent crime, pretrial publicity may have convinced members of the community, including the potential juries, that a defendant is guilty. But in most instances, a judge has the authority to change the venue of the trial to increase the likelihood of an unbiased jury. With the standard of proof, the state must prove the defendant's guilt beyond a reasonable doubt. The prosecution must show that based on all the evidence, the defendant's guilt is clear and unquestionable. And this high standard of proof in criminal cases reflects a fundamental social value. And that's this belief that it is worse to convict an innocent individual than to let a guilty one go free. There is a high standard that is placed for proof on the prosecutor, and it really reduces the margin of error because of this. How is jury selected? So the selection of jury takes place with a process called voir dire. And the initial step involves choosing the jury. And the main goal of jury selection is to produce a cross-section of the population in the jurisdiction where the crime was committed. For the most part, jurors must be citizens, 18 years of age or over, free of felony convictions, healthy enough to function in a jury setting, sufficiently intelligent to understand the issues of a trial, able to read, write, comprehend the English language. And what happens is a master jury list is made, and this is called the jury pool. And it is made up of all the eligible jurors in the community. And so the next step in gathering this jury to draw together veneer Latin for to come. The venire is composed of all those people who are notified by the clerk of the court that they have been selected for jury duty. And at the courthouse, this process of voir dire starts. And this is where prospective jurors are gathered, and there's this process of selecting those who will actually hear the case. The court ultimately seeks jurors who are free of any bias. Therefore, being former law enforcement, I will probably never, ever, ever be able to appear on a jury or work on a jury, which I think would be great fun. The court ultimately seeks jurors who are not only free of biases, but they're willing to listen, to stay, and to hear the case impartially. And to this end, both the prosecutor and defense attorney have some input into the ultimate makeup of the jury. Each attorney questions prospective jurors, and that's this process of voir dire. And during voir dire, jurors are required to provide the court with a significant amount of personal information. So there are some challenges that come up with getting potential jurors, and that will be seen through that process as they're selecting the jurors. Sometimes the inquiries are fashioned in a manner that makes jurors uncomfortable, but they also allow for bias or other perspective issues to come forth at that point. So when we talk about challenges for cause, if a defense attorney or prosecutor concludes that a prospective juror is unfit to serve, the attorney may exercise a challenge for cause and request that the person not be included. But attorneys must provide the court with a sound, legally justifiable reason for why potential juries are unfit to serve. Now, each attorney may also exercise a limited number of peremptory challenges, and these challenges are based solely on an attorney's subjective reasoning, and the attorney is usually not required to give any legal justifiable reason, but because rather the random nature of the peremptory challenges, each state limits the number that an attorney may utilize. We are going to stop now and take a little break.